Justice delayed is justice denied. 2 centuries since William Gladstone said these words, they remain relevant, especially here in India. Look around you. Swift justice is still elusive. There's an ever-growing backlog in Indian courts, a chronic pendency of criminal appeals. Cases drag on for years and are sometimes resolved after a litigant has died. I'll give you an example from Maharashtra. A 108-year-old man passed away before India's apex court could even hear his appeal. His name was Sopan Narsingha Gaikwad. In 1968, he filed an appeal in a land dispute. For 27 years, the case was pending before the Bombay High Court. Then it was dismissed. He challenged this dismissal. The appeal was finally accepted last year. The Supreme Court of India finally agreed to hear the case, but Gaikwad was no longer alive then. And this case is not an exception. You may have heard of the 1984 Bhopal gas tragedy. The Union Carbide factory ruined the lives of 5 lakh people. The gas leak of 1984 still poisons the lives of those who live here. But their case is yet to be concluded. Only 7 employees have been tried and convicted, and that too for just 2 years in jail. Plus, the company involved avoided all liability. It agreed to pay millions in compensation, but most victims have not received a single penny.
30 साल हो गई पैसे मिलते हैं कम 1.5 से कम 2 से ऐसे मिलते पैसे भी नहीं मिल रहे परेशानी भुगत रहे बात
3 decades, no money, no justice. We put courts and judges on a pedestal. We say, see you in court with a believer's confidence, even though we know that India's judicial system does not work within reasonable timelines. There are millions of pending cases, so we must ask, is this legal logjam defeating the very purpose of the institution? Hello and welcome to Gravitas Plus. I'm Palki Sharma Upadhyay. There are about 73,000 cases pending before the Supreme Court of India and about 44 million cases in all courts of India. Out of these, 8 lakh cases are more than a decade old. 1 lakh cases have been pending for 20 years and almost 2,000 cases have been on hold for 50 years. Half a century. They say no one is guilty until proven, yet we have thousands of under trials languishing in jails. An under trial is a person yet to be tried for a crime. Do you know how many under trials India has? According to a January 2022 report, nearly 76% of India's prison population is made up of under trials. 76%. That is 3 in every 4 prisoners. 2 years back, another report was released. It said that there were more than 1,200 under trials. And listen to this carefully. There were 1,200 under trials who had been in jail for a period that would make up half the sentence their alleged offences qualify them for. Some of them are even eligible for release, but are still in jail. What's worse is that 49% of these under trials are between 18 to 30 years of age. That's nearly half of all under trial inmates in India, young men and women languishing in jails even though a court has not pronounced them guilty. This is nothing short of tragic. And it's thanks to India's legal backlog. In 2018, India's central planning body, the Niti Aayog, shared some interesting insights. It said that at the current rate, it will take more than 324 years to clear the backlog. 324 years. And that's only if fresh cases are not filed, which, by the way, is not happening. Fresh cases are coming at an alarming rate. Another study says that in the last 2 years, India has added 23 cases every minute to its list of pending cases. 23 cases every 60 seconds. You know what this means? A difficult time for the litigants and a negative impact on India's economy. According to a 2016 report by the Tata Trust Organization, judicial delays cost India around 0.5% of its GDP every year. That's around 50,000 crore rupees every year. What's worse, none of what I've just told you is a secret. India's highest judicial officers and those in government are all aware of this. In November 2021, President Ramnath Kovind spoke about the judicial logjam. In September 2021, Union Law Minister Kiran Rijiju urged local courts to show urgency in resolving cases. And just last week, the former Chief Justice of India, S.A. Bobde, acknowledged the pendency of cases. So everyone agrees there's a problem. Why aren't they solving it? Why do Indian courts remain sluggish? I could give you multiple reasons. There aren't enough judges, not enough judicial officials, insufficient investigations, poor physical infrastructure, and a lack of clear mandates. Most Indian courts do not have basic facilities. 26% of court premises have no separate toilets for women. 16% do not have any toilets at all. Only 54% have clean drinking water. Only 27% of the courtrooms are digitized, meaning they have computers on a judge's dais. The rest do not. Only 32% courts have a separate record room, a storage facility for journals and documents. The rest of them do not. Then there is staff shortage. As of February 2020, 21% of the posts for judicial officers had not been filled. That's more than 5,000 vacancies, mostly in these states. As for judges, there are about 400 positions lying vacant across 25 high courts in India. Lower courts are worse off. They have 5,000 vacancies. That leaves India with one subordinate court judge for more than 50,000 people. Simply put, India is short of resources. And where we have judges, we sometimes do not have a courtroom. According to India's Chief Justice N.V. Ramana, nearly 20% of judges in India do not have proper courtrooms to sit in. Why have we not been able to fix this problem? India spends only 0.08% of its GDP on the judiciary, and this money covers salaries, allowances and operations, which leaves very little for capacity building and infrastructure rehaul. But you can't blame the backlog only on resources. There's a culture of seeking adjournments, or what lawyers call luxurious litigation, a culture where people with resources attempt to frustrate the courts. They make numerous appeals from a district court to a high court to a Supreme Court in a bid to delay the judicial process and evade the law. In the year 2000, the Indian judiciary tried putting an end to this. They set up 1,700 fast-track courts across the country. The idea was to deliver speedy justice. But more than 2 decades on, fast-track courts are a sluggish affair. In New Delhi, a fast-track court takes 122 days on average to wrap up a case. A regular court takes 133 days. What does that tell you? That fast-track courts are not fast. They defeat the purpose. According to the NCRB's data, 29,000 cases were resolved by these courts in 2019. Nearly 81% of them had been on trial for at least 10 years. So let me say this. This is denial of justice. It is undermining the credibility of India's judiciary. It is insulting the constitutional value of human dignity. Millions of cases are gathering dust with no judges to deliver justice on time. How do we end this vicious cycle? How do we clear India's legal logjam? We spoke to experts and made a list of 5 solutions, 5 very simple judicial reforms. Number 1, fill vacancies, appoint more judges. If all sanctioned judges and staff were to be appointed, the mounting pendency could be history. Solution number 2, use technology to digitize courts and streamline legal processes. This could end the problem of bench fixing. Influential people are able to get their cases heard on priority. Cases of weak and poor undertrials are adjourned endlessly. And this has to end. Technology can be used to develop an algorithm where the first in, first out basis is followed in listing cases, not power and influence. Solution number 3, set up more virtual courts. They can save a lot of time and money. The Supreme Court launched an e-committee back in 2005. The aim was to hold virtual hearings. But for the last 17 years, this has been done as an exception only. The pandemic changed things a bit. Courts did go virtual, but only for select cases. It's time to do more of this. Solution number 4, promote alternative dispute resolution, ADR. In other words, settle disputes outside courts. How do you do that? Through arbitration, through mediation, negotiation. The concept is already laid out in the Code of Civil Procedure, but it's not used enough. Using this to solve minor disputes can lower the burden of courts. And lastly, central tribunals can be made the last resort in the judicial process. They already exist, but their orders can be challenged. If we limit the scope of appeal for certain matters and let the tribunals take the final call, we can ensure that cases do not get dragged endlessly. You can challenge each one of these solutions, but you've got to start somewhere and start immediately. Everything has moved on the fast track. Passport delivery, travel bookings, bank transactions, medical services. In every field, we have used technology to speed up processes. Why should courts remain the exception? We all operate with deadlines in every field of work. Why not in the judiciary? Accountability improves systems, and as a country, we have to be accountable to the millions of people languishing in jails, wasting their lives, or waiting for justice.